Good evening. It is my distinct pleasure to welcome you to Washington Lee Law School this evening to celebrate the creation of a new chaired professorship in the School of Law, the William Donald Bain Family Professor of Corporate Law, and to honor its inaugural recipient, Professor Christopher Bruner. The chaired professorship was made possible through a remarkably generous gift by William Donald Bain, Jr., whom we are fortunate to have with us this evening. Mr. Bain is joined by his friend Cabell Mitchell, his daughter Nancy Cote, and Nancy's husband Paul Cote. I would like to begin by providing some background on Mr. Bain's career and the numerous ways in which he has supported educational causes throughout his lifetime, both through personal efforts and financial support. A native of Rochelle, Illinois, Don Bain came to Washington Lee School of Law after earning a Bachelor of Science in Economics from the University of Pennsylvania's Wharton School of Business. During his time as an undergraduate student, he served in the Army Air Corps from 1943 to 1945. At Washington and Lee, he was a member of the Sigma Alpha Epsilon fraternity, and he was a member of the Phi Delta Phi and Phi Alpha Delta legal fraternities. Following graduation from the law school in 1949, Mr. Bain began his career as a field representative for the Travelers Insurance Company. He passed the South Carolina bar in 1951 and found his true calling not in the practice of law, but in business. Married to Pat Thomas of Spartanburg, South Carolina, Mr. Bain was lured to Spartanburg by his father-in-law, Paul Thomas, to learn the operations of the family's chemical business, the Moreland Chemical Company. Mr. Bain worked for Moreland Chemical for 36 years, serving the last 20 years as the company's president. Mr. Bain oversaw the merger of the company into McKesson Corporation in San Francisco. And even though Mr. Bain did not spend his career practicing law, this certainly gave him the opportunity to make good use of the legal education that he received at Washington and Lee, because in my conversations with Mr. Bain earlier this semester, he noted that he and others negotiated this merger transaction on behalf of Moreland Chemical Company, and in the process might have taught the somewhat elitist and arrogant lawyers on the other side of the transaction from San Francisco a thing or two. After the merger was completed, Mr. Bain commuted between Spartanburg, South Carolina, and San Francisco. I'm not sure if there's a direct flight between the two. Maybe they created one at the time. But he continued to work for McKesson, and he retired as vice president and general manager of that corporation's industrial chemical division. Mr. Bain went on to co-found the Affiliated Chemical Group, a national organization of non-competing chemical distributors from all over the United States, and he served as that organization's first president. Mr. Bain has been involved with education in some form or another for pretty much his entire life. He was a member of the Spartanburg City School Board, serving as its chairman throughout the years of integration. He has served on the boards of Hollins University and Converse College, and at Converse College he served as the chairman of the board for 8 years. Mr. Bain also is a member of the Board of Trustees of the Walker Foundation, which supports the South Carolina School for the Deaf and the Blind, and Cedar Springs Academy. Mr. Bain has served Washington Lee University, in particular, in a number of capacities. He has been a law class agent, the alumni board director, member of an area committee for the On the Shoulders of Giants campaign. He has served on the Development Council, and he is a member of the George Washington and the Doremus Societies. Mr. Bain was honored with a Distinguished Alumnus Award in 1987, and in 2007, he was inducted as an honorary member of the law school's Order of the Coif. Mr. Bain has been generous to the Washington and Lee School of Law by supporting the Dean Roy L. Steinheimer Jr. Professorship, the Class of 1949 Law Fellowship, and the School of Law Library. And of course, this evening we are here to celebrate Mr. Bain's endowment of the William Donald Bain Family Professorship in Corporate Law, a chaired professorship that Mr. Bain has created to honor his father. Mr. Bain continues to reside in Spartanburg, and he has 3 daughters. Thank you very much, Mr. Bain. Now let's turn to the inaugural recipient of this chaired professorship, Professor Christopher Bruner. I'm going to turn the floor over in a second to my colleague David Millen, who will say a few words about Christopher's remarkable career to date. But before doing so, I should note that my colleagues and I at Washington and Lee Law School are thrilled to see Christopher receive this honor. He's truly an excellent faculty member in all facets of the position. He's committed to excellence in the classroom. He excels in his research pursuits, and he serves the law school in a number of critical capacities. In fact, right now he's serving as the director of the Francis Lewis Law Center, and he certainly does everything the law school could ever ask, and we benefit greatly from Christopher's presence on our faculty. I would also like to note that Washington and Lee Law School has benefited from a remarkably strong corporate law faculty over the years, a specialty area that has been anchored by two individuals in particular, David Millen and Lyman Johnson, both of whom have really devoted their careers to this law school and have established Washington and Lee on the national scene in terms of corporate law. Christopher follows in their remarkable footsteps, and I believe he will continue to make Washington Lee Law School an excellent training ground for future transactional attorneys and business professionals. With that, I will turn the floor over to my colleague David Millen. Thank you very much to all of you for being here tonight to celebrate this remarkable creation of the chair professorship and its awarding to Professor Bruner. Thank you.
Thank you, Brant, and thank you to the Bain family for your generous gift. Gifts like this are crucially important for the law school's ability to recruit and retain a top-notch faculty, and we're very grateful for your all support. So thanks very much. I'm going to be brief because, of course, Christopher is the star of the show, and we're all eager to hear him speak, but I do want to say a few words about why he is so deserving of this honor. Christopher is an outstanding teacher. He's a leader in the governance of the law school, and he's also a great colleague, and I've learned a lot from him in the corporate law area since he's been here, and I'm very grateful for that. But I want to take a minute or two just to focus on his scholarship, on his writing, hoping to give you some idea of why he is such a creative, insightful, and important figure in the field of corporate law. Christopher has published over a dozen articles on corporate governance, corporate purpose, fiduciary duty, and other topics, as well as many, many shorter pieces. He is the winner of the ALS Scholarly Papers Competition in 2010. He's twice been honored by our faculty for scholarly excellence. All of this would be enough to establish Christopher's standing as a leading corporate law scholar, but he's also the author of a truly brilliant and important book, and he's well on his way to publishing a second book. This is extremely unusual for a scholar at this stage of his career to have two books. The second one will be out next year. So let me say a little bit about the first book. This was published by Cambridge University Press in 2013. It's called Corporate Governance in the Common Law World, the Political Foundations of Shareholder Power. And the central question that Christopher is concerned with in this book is the extent to which shareholders of public companies are able to exert control over management in order to further the shareholders' own economic interests. And this is an important question because often this can come at the expense of non-shareholder stakeholders, workers, creditors, others. So, for example, if corporate law allows shareholders free access to hostile tender offers, shareholders can earn big profits by tendering their shares, but the result, because these deals are highly leveraged, is that post-takeover, you can experience plant closings and other harmful effects on employees, creditors, suppliers, local communities. So it's been widely assumed that corporate law in the US, the UK, and the other common law countries answers this trade-off question, shareholder interest on the one hand versus shareholder and non-shareholder interests on the other, in essentially similar ways. But Christopher makes two very important and original contributions to the analysis of this question. First, he shows that U.S. corporate law, in fact, is quite ambivalent about shareholder power, and in fact gives managers broad leeway to sacrifice shareholder interests for the interests of other corporate stakeholders, particularly workers. In contrast, UK corporate law, and Canada and Australia as well, is much more shareholder-centric. So this itself is an important contribution because comparative corporate law scholars tend to contrast the common law world in continental Europe and assume that the common law world is essentially homogeneous. And Christopher shows here that that is not the case. But he goes further than showing this. He actually offers a compelling political explanation for the divergence. And this is what it is in a nutshell. I hope I do you justice here, Christopher. In the UK, Canada, and Australia, there is a strong tradition of robust social welfare programs, including publicly funded health care, income protection, and retirement benefits. And the point here is that this has allowed, this feature of political economy in these countries has allowed corporate law to focus on the interests of shareholders, to prioritize the interests of shareholders over those of these non-shareholder stakeholders, without concerns about political backlash. So strong social welfare safety net translates to strong corporate law for shareholders. The U.S. story is different. Traditionally here, of course, health care, retirement, and other benefits have been linked to employment rather than being provided publicly by the government. U.S. corporate law's ambivalence about the interests of shareholders versus non-shareholders reflects political concerns about corporate law rules that would overprivilege shareholder interests at the expense of non-shareholders. So weak social welfare safety net, weaker corporate law from the shareholder's perspective. It's a fascinating and really, truly a brilliant book. It's received a great deal of attention and a lot of positive reaction. It's been reviewed widely. And this book has, I think more than anything else, established Christopher as one of the a small handful of leading scholars in the world in the field of comparative corporate law and corporate governance. The new book promises to be equally fascinating, creative, and important. This book, which will be published by Oxford University Press next year, is called Market-Dominant Small Jurisdictions in a Globalizing Financial World. And the idea, this is really cool, the idea here is he's focusing on certain small jurisdictions that have managed to become dominant players in various corners of the global financial marketplace. So, of course, we have Delaware in corporate law. We know about that. We have Switzerland in private banking. We know about that. But you also have Bermuda in insurance. You have Singapore in wealth management. Hong Kong has emerged as the critical gateway to and from mainland China. And now Dubai has taken a leadership role in Islamic finance. So Christopher's goal here in looking at all of these different phenomena is to try to identify common characteristics of these countries or jurisdictions and common strategies that they have used to achieve their dominant position, which has allowed these small jurisdictions to achieve dominance over much larger, much more powerful rivals. The book promises to be rich and detailed. Christopher has literally traveled the world doing the research for this book. And he's also going to provide a very original, insightful theoretical analysis of this fascinating phenomenon. And it's only going to enhance further Christopher's position as one of the leading corporate law scholars in this country and really in the world. In short, there really could be no more worthy recipient of the Bain Family Professorship of Corporate Law than Christopher Bruner.
Well, thanks so much to Brant for convening this event and to David for that very kind and I think it's fair to say very generous introduction. Many thanks to all of you for attending tonight, including my wife Leah, who's had to hear more corporate law talk over the years than any innocent civilian should have to endure. But without whom, it has to be said, nothing that I've written or done of any importance would have happened. So my deepest thanks go to Leah, as well as to our son Cullen, who is also joining us this evening, as well as to our daughter Claire, who is not. She is at home with a sitter. We decided that there would be plenty of time for lectures on corporate law once she's got elementary school under her belt. I also want to express my gratitude to all of my colleagues from the faculty, staff, and administration here at Washington and Lee, whose support and guidance have really opened numerous doors for me, both professionally and intellectually. There are too many to name, but I am particularly grateful to David and to Lyman Johnson, our colleague in corporate law, who are perhaps the best senior colleagues that an aspiring corporate law scholar could conceivably have had. And I also want to note our colleagues Mark Drumble and Russ Miller, who are perhaps the best senior colleagues who an aspiring comparative law scholar could conceivably have had. I also have to convey my deep appreciation for our fantastic students. Their energy, their intellect, and their good nature are really the animating spirit of this place. And it's been my great good fortune over the years that I've been here to have the opportunity to work with those folks day in and day out. Now, most of all, as Brant noted, tonight provides an occasion to express our gratitude to Don Bain for all that he's done to advance the work of the law school and the study of corporate law in particular. For all the reasons that Brant noted a few minutes ago, Don has really set a remarkable example for all of us in so many ways, from his great professional successes over a decades-long career in business to his wide-ranging public service in his community of Spartanburg, South Carolina, and in multiple institutions of higher education, to his depth of involvement and leadership with Washington and Lee in organizing alumni events and campaigns, to his great generosity and, I dare say, vision in establishing the William Donald Bain Family Professorship in Corporate Law. As was noted earlier, this professorship is named for Don's father, and I understand that it's also to some degree inspired as well by the value that Don's own study of business law here at Washington and Lee brought to his career as a corporate executive. W&L, as was noted, has long been recognized as a center of innovative teaching and scholarship in the field of corporate law, and Don's generous gift is most assuredly going to help us continue to build on that tradition moving forward. Certainly, I can say that every time that I enter the classroom here in Lewis Hall, I aspire to convey the sort of lasting value that Professor Charlie McDowell conveyed to Don when he took his business law course over in Tucker Hall. And it is truly an extraordinary honor for me and a great pleasure to be the inaugural holder of the Bain Family Professorship. Now, in light of everything that I've just said, I think it's fitting that my remarks tonight focus on what I regard as one of the most fundamental and enduring challenges for teachers and scholars of corporate law, and that is identifying and conveying what the intrinsic attributes of our core subject of study even are. When we talk about a corporation as distinct from any of a number of other human institutions and business forms, what do we mean? What is it that makes a corporation a corporation? This is a hugely consequential matter, not least because these legal entities are among the most consequential economic actors on the planet. What is it precisely that they consist of? How is it that they unlock such extraordinary capacity for productive activity? Having comprehensible answers to these questions will be critical if we hope to foster those capacities moving forward, and it has to be said if we hope to contain and channel those extraordinary energies toward what could be regarded as socially beneficial or at least not obviously detrimental. Now, I want to suggest tonight that efforts to identify a set of fixed intrinsic corporate attributes have largely missed the mark, principally because they're in tension with the history of the corporate form, which in fact has been defined by a very high degree of flux and dynamism over time. Now, ironically, contemporary efforts to identify such a set of fixed intrinsic corporate attributes, in spite of themselves, implicitly continue to reflect that dynamism, because when you take them together, the various efforts to depict the corporation as some sort of singular essence actually end up differing from one another quite a bit in ways that are both significant and irreconcilable. Now, this is a reflection, I think, of enduring uncertainties and disagreements about what corporations actually are, to touch on some of the points that David noted a few minutes ago, and how they ought to function. In developing this argument, I'm going to touch on what I regard as illuminating historical contrasts between U.S. and English law, And I'll wrap up by suggesting that we would do well to reconceptualize what is truly intrinsic to the corporate form. At that point, I'll set out for you a framework that I've developed in my contribution to an edited volume on corporate governance theory that'll be published next year by Cambridge University Press. Now, I'll turn to some varying conceptions of the corporation's intrinsic attributes shortly, but Bob Clark's account in his highly regarded treatise on corporate law gives us a good starting point. Numerous resources on corporate law provide accounts that broadly resemble this formula, emphasizing legal personality, that is a sort of integrity to the entity as distinct from the constituents of the entity. Limited liability for shareholders, meaning they generally can't lose more than the money that they invested in the business. Free transferability of equity interests, by which we're referring in a corporation to stock. And centralized management through a board of directors. Now, these are all obviously recognizable as prevalent features of business corporations today. But as a threshold matter, it's critical to recognize that there wasn't some magic moment in time when they all sprang into the world together as a fully formed system. So how did it happen? Let's briefly consider the history. Early accounts of the corporation's utility emphasize its capacity to provide a stable vehicle for ongoing deployment of assets toward various types of collective goals that were expected to outlast the involvement of particular individuals. And of course, this core utility would apply not just to businesses, but also to various types of non-business institutions as well, including religious organizations, municipalities, and of course, universities, this one included. In essence, we needed an institution that could transcend the mortality of its individual constituents. And in describing this abstract, transcendent function, early accounts often turned to vivid simile and metaphor. So Sir Edward Coke, for example, writing in the 17th century, famously described the corporation aggregate of many as an invisible and immortal collective entity. Sir William Blackstone, writing in the 18th century, described the corporation as a person that never dies, in like manner as the river Thames is still the same river, though the parts which compose it are changing every instant. Who said corporate law couldn't be poetic, right? In like manner as the river Thames is still the same river, though the parts which compose it are changing every instant. Now, Blackstone's 18th century contemporary, Sir Matthew Bacon, employed the metaphor of the body politic, a different way of looking at it. The ligaments of which are the franchises and liberties thereof, which bind and unite all its members. So we have some different points of emphasis here, some different evocative images for what the corporation is, but fundamentally they have a commonality. They all evoke continuity. And scholars today continue to dig into the value that this distinct and continuous legal entity with an integrity that stands apart from that of the individuals who compose it. It's a very, very important concept. Particularly noteworthy in the business context, I think, is the concept of entity shielding that Henry Hansman, Rainier Crackman, and Richard Squire have explored. This refers to the capacity to protect business assets from the personal creditors of the individual investors. This effectively circumscribes a stable pool of assets to which commercial and financial counterparties could look to assess the creditworthiness of the business as such. Now, beyond this generic foundation, though, the story of how we actually arrived at the modern business corporation is very heavily impacted by historical, cultural, economic contingency and idiosyncrasy. In England, the so-called incorporated joint stock company of the 17th century was a great start. It offered a stable entity that eliminated the right of individual investors to withdraw assets, which could be very destabilizing for the business, while at the same time granting them the right to sell their shares without the consent of the other investors. This rendered the business's asset pool more stable while ensuring that investors had some form of liquidity, by which we mean ability to get their cash out. Now, the practical problem with reliance on the incorporated joint stock company was simply that Parliament was stingy with charters. So what did clever English lawyers do? They developed a workaround that they called the unincorporated joint stock company. This synthetically approximated a chartered company through a partnership in which the business assets were then placed in a trust governed by trustees who were elected by the partners themselves. Shares were tradable, and business assets were shielded from asset withdrawal and investors' personal creditors by the trust structure. Now, the fact that this could be built on the foundation of a general partnership made these features much more widely available for businesses. In fact, by the turn of the 19th century, there were almost 1,000 unincorporated joint stock companies in England. And critically, note that this occurred without substantial reliance on limited liability for investors. Some incorporated joint stock company charters did provide for fully limited liability, but many didn't. Likewise, some unincorporated joint stock companies sought to limit liability contractually, but this approach wasn't clearly endorsed by the English courts until the mid-19th century, so it couldn't really be relied upon in terms of developing this business form. While general incorporation became available in England in 1844, which allowed incorporated entities to be created without requiring these one-off acts of the Parliament or the Crown, it wasn't until 1855 that limited liability was even reflected in the statute at all, and at that point it was only available for companies that had 25 investors or more. That's a threshold that would be phased out only gradually over the course of several decades. Now, the history in the US differed in some respects while resembling the English experience in others. We began with so-called special charters granted by state legislatures, often for quasi-public undertakings like bridges, canals, and the like. And this broadly resembled the English experience with incorporated joint stock companies. Now, general incorporation and limited liability both arose earlier in the US. They were both introduced by New York in 1811. But for the US writ large, the overall trend resembled that in England, with general incorporation becoming widely established long before limited liability for investors did. In California, in fact, shareholders faced unlimited pro rata personal liability for business obligations until 1931, well into the 20th century. Now, viewed through this historical lens, the modern corporation takes on, I think, quite a different cast. Again, there's no single moment when the corporation as we think we know it sprung into the world as a fully formed system. While capacity to deploy collective assets would indeed appear central to any business entity, beyond that we can really only speak in terms of generalized trends and tendencies. Now, to be sure, trends toward a stronger liability shield for shareholders, freer transferability of stock, and greater centralization of management power in the hands of the board are readily discernible in each of these countries, and their association with industrialization is broadly understood. I'll come back to that in a moment. But these generalizations provide very little, if any, guidance when we turn to the truly fundamental questions of corporate governance that face us today. Notably, what should the division of power be between boards and shareholders? To what degree should corporate decision-making focus on the interests of investors, the shareholders, versus some broadly defined category of stakeholders? What should the degree of risk exposure be for boards and shareholders alike? And how might the answers to these questions differ from one industry context to another? Now, as I noted earlier, many current formulations of the corporate form broadly reflect the trends I just outlined. Here we've got just a handful of examples from prominent reference materials on US corporate law. Now, we can see across these examples a general resemblance to Clark's list, but note that we have some interesting distinctions. In characterizing the nature of corporate power, William Allen, Rainer Crackman, and Guhan Subramanian emphasized the significance of the shareholder franchise, that is, the shareholder's right to elect the board. Stephen Bainbridge, on the other hand, characterizes corporate power by reference to a separation of ownership and control, referring here to the notion that the corporation, by its very structure, drives a wedge between holding an equity interest on the one hand and having actual governance power on the other. So why the difference? Well, Bill Allen, back when he served as Delaware Chancellor, penned a famous opinion in the 1988 Blasius case, in which he characterized election of directors by shareholders as, quote, the ideological underpinning upon which the legitimacy of directorial power rests. The idea seems to be that the true legitimate font of power is the shareholders, and it's only derivative of that legitimacy that the board can be said to really hold legitimate power. Bainbridge, on the other hand, gave us what's called the director primacy theory of the corporation, which styles the board of directors as, quote, a sort of platonic guardian whose powers flow not from shareholders alone, but from the complete set of contracts constituting the firm. Here we're pointing toward the idea that governance power doesn't really come from the shareholders, it comes from the state, right? That once elected, the board's power is original and undelegated, as it's sometimes referred to in the case law. Now, it's critical to recognize that these conceptions of the source and legitimacy of corporate governance power are fundamentally incompatible. And that's manifested here in irreconcilable conceptions of this intrinsic, purportedly intrinsic aspect of the corporation. Now, like Bainbridge does, William Klein, John Coffey, and Frank Partnoy characterize governance power by reference to a separation of ownership and control, but they add these other elements that tend to decentralize shareholders further, while at the same time pointing toward a distinct set of concerns that seem rooted more in risk, time horizon, and financial stability. Klein, Coffey, and Partnoy explain in their treatise that the shareholders' inability to withdraw assets, quote, protects the stability of the corporation and the interest of the other shareholders in that stability. But they suggest that a more important function may be that it, quote, protects the creditors of the corporation, who, as we noted earlier, can extend credit to the business knowing they've got downside priority over the personal creditors of the shareholders. Now, the diversity of concerns and views that we see here from respected scholars, all purporting to describe the same phenomenon, the U.S. corporation, suggests that these fixed static formulations of the corporation's intrinsic attributes may not offer so much analytical value when it comes to resolving the fundamental issues of power, purpose, and risk-taking that continue to vex us today. So let's just briefly consider a few U.S. examples that illustrate this. In Delaware, which is the legal home of most publicly traded companies in the United States, particularly thorny issues have arisen from the shareholders' unilateral authority to amend the bylaws. This is the governance document that typically sets out the mechanics of procedural governance within the company. This power could, in theory, be used to aggressively carve back at the board's management authority, including by constraining boards' capacity to insulate their companies from hostile takeover attempts of the sort that David referred to earlier, which in turn raises important issues about whose interests are supposed to drive corporate governance in the first place. When a would-be acquirer makes a premium bid for the stock of a target company to secure control over that company, should we favor the shareholders' interest by allowing them to hand over control of the company in exchange for that premium price? Or should we favor employees, managers, creditors, maybe even local communities, all of whom reasonably fear that in the aftermath of the takeover, there could be a consolidation or a breakup of the company that really compromises their interests? Now, it's critical to recognize that the Delaware statute offers no guidance whatsoever on how to resolve these types of questions, and Delaware's courts, when they've dealt with them, have struggled mightily to resolve these matters in a way that sounds judicial. Because in reality, the legislative vacuum places them in a position where they have no choice but to legislate. Now, with bylaws, the court decided that the board's management authority trumps because board management is a, quote, cardinal precept of corporate law, whereas the shareholders' ability to amend bylaws is not. Offering no explanation of how we know a cardinal precept when we see it, this effectively amounts to burying the conclusion in the premise. With takeover defenses, then, the court created a muddled case law that awkwardly subordinates shareholder power to accept a hostile bid by reference to the shareholders' own interests. Again, bearing the conclusion in the premise, in this case by asserting a duty for the board to protect the shareholders from themselves. For example, the shareholders might just fail to appreciate the wisdom of the board's own long-term plan for the company as opposed to that of the hostile raider. But at the same time, the court also suggested in this case law that other stakeholders' interests could matter as well, which certainly appears consistent with the board-centric outcome, but not with the shareholder-centric rationale of the approach. Now, personally, I'll say that I actually like these outcomes in both areas. But let's be perfectly candid. None of this is deducible from first principles of the corporate structure. And that reality is only underscored by comparison with the UK, where shareholders are granted far greater power to unilaterally determine the content of core governance documents for the company, as well as the outcome of hostile takeover bids, of which more in a moment. Now, another fundamental issue that's come front and center after the recent financial crisis is how to calibrate risk-taking incentives within corporate America, particularly the financial industry. Here, it's particularly important to recall the history that I described earlier, which vividly illustrates the non-inevitability of fully limited liability. Now, Henry Hansman and Rainier Crackman, for example, have made much of this history in advocating a regime of unlimited pro rata shareholder liability in the context of tort, an approach that they argue would help us avoid incentivizing excessive investment in hazardous industries where we might have a prospect of harms that exceed the corporation's net worth. Now, others, including me, have similarly argued that to curb the sort of financial risk-taking that preceded the crisis, we should revisit certain aspects of late 19th and early 20th century banking law that were expressly aimed at managing risk. Namely, a stronger duty of care for the board, sometimes accomplished through diminished business judgment rule protection, greater regard for depositors, a category of creditors who were in many cases treated as direct beneficiaries of fiduciary duties, and a weaker liability shield for shareholders whose appetite for risk correlatively diminished. Under so-called double liability rules, shareholders of a failed bank not only lost their investment, but it could actually be assessed for that amount of money again to create a pool of assets available to creditors, a strategy that was also employed in Australia, Canada, and the UK. Now, whatever any of us may think about these specific proposals, for present purposes, the point is simply the non-inevitability of the features of the corporate form as we think we know it. To state the point more generally, there is no deducing correct answers to any of these questions from purportedly intrinsic corporate attributes. In each instance, it's inevitably going to be a matter of politics, in some cases distributive politics. Why does U.S. law on hostile takeovers empower boards and permit consideration of various stakeholders' interests, while the UK focuses like a laser on the shareholders, giving them straightforwardly the power to determine whether the hostile bid goes ahead or not? As David noted, as I've discussed in a recent book, UK labor leaders in the 1960s decided that takeovers would be a good thing because they would be a way to foster bigger, more globally competitive companies. And they were confident that the more robust UK welfare state could buffer the downsides for employees, who of course were the core constituency of the Labour Party. In the US, on the other hand, state legislatures and sometimes judges in the 1980s saw little social benefit in these very highly leveraged hostile takeover bids, and they feared that terminated employees left to the weaker US welfare state could be more vulnerable. Now, it's critical to recognize these contrasting outcomes weren't driven by anything intrinsic to corporate law or the corporate form. They were driven from the outside. They were driven by the broader political economy that corporate law inhabits. Shareholder-centric theories might seem to derive some force from the UK experience. Board-centric theories might seem to derive some force from the US experience, but in the end, I think these dynamics have a lot more to tell us about idiosyncrasies of the British and American political economies than they do about any purportedly universal laws of economics. Now, in light of the foregoing inconsistencies and indeterminacies, what are we to do? How should we present corporations to our students, to practitioners of corporate law, to judges who are grappling with disputes that raise these fundamental issues of power, purpose, and risk-taking, and to policymakers who, it bears emphasizing, are duty-bound to channel these entities toward activities that are at least broadly compatible with the public interest? I'm going to conclude my remarks tonight by suggesting that in light of the foregoing, it would pay to rethink how we conceptualize the corporation's intrinsic features. Rather than speaking of a singular structure with fixed static characteristics, as virtually all of the authorities in the subject do, we might speak in terms of the tools that the corporate form offers and how those tools can be deployed toward various types of ends. From this perspective, the corporation is more accurately and I think more productively depicted as a dynamic system, a complex governance machinery with a variety of levers, if you like, that can be set in different ways to address different types of problems. These levers would minimally include varying degrees of governance centralization, which speaks to the division of power between boards and shareholders, varying degrees of board liability exposure and shareholder liability exposure, which goes toward risk-taking incentives within the company, varying degrees of express shareholder orientation, suggesting that we might have different ideas about whose interests ought to be prioritized in different types of contexts, and varying degrees of share transferability, which relates in various ways to the foregoing. Now, you'll immediately perceive here that this schema draws from the sorts of features we considered earlier, but differs from them by expressing each of them as a spectrum. So, if we start with these possibilities expressed visually in this manner, as a series of levers that we can adjust in different ways, what does the typical publicly traded company in the United States look like? It looks something like this, reflecting relatively high governance centralization through a powerful board, low liability exposure for the board and shareholders alike. The board is protected by the business judgment rules, statutory exculpation of duty of care liability, statutory indemnification, directors and officers insurance, and then shareholders, of course, are protected by fully limited liability. Then we've got relatively high shareholder orientation stemming from the shareholder's privileged status as a direct beneficiary of fiduciary duties in this publicly traded context, reinforced by securities regulation and various capital market pressures. Then we've got high share transferability, reflecting the ability to buy and sell stock in a deep liquid capital market. Now, note that if we were to employ this kind of depiction comparatively, then we might have to make various adjustments. For example, if we take this US depiction as our baseline, and then we want a comparable depiction of the UK public company, we'd have to adjust in various ways to reflect somewhat lower governance centralization due to the fact that British shareholders have a lot more direct governance power than their US counterparts do. We'd have to adjust to reflect somewhat higher shareholder orientation. The statute in the UK shows a lot more direct, clear, express regard for the shareholders' interests than do statutes in the United States. And we'd have to adjust to reflect for somewhat higher share transferability, reflecting the unfettered capacity of British shareholders to accept hostile takeover bids regardless of what management or anybody else might think about the matter. Now, this mode of depiction of the typical public company underscores again the non-inevitability of this particular set of calibration of the levers. So if we exercise the creative capacity that this depiction invites, or at least is intended to invite, then what might some other possibilities look like? Well, think back to Hansman and Crackman's proposal for unlimited pro rata shareholder liability and tort. It would look something like that, with somewhat higher shareholder liability exposure. If we were to return to the sort of approach historically applied to banks in our modern financial sector, it would look something like that, with higher liability exposure for shareholders and the board alike through multiple liability rules for the former and a stronger duty of care for the latter, and then somewhat lower shareholder orientation reflecting bank depositors' status as a direct beneficiary of fiduciary duties. As the schema implies, there are many possibilities indeed. Now, as I suggested earlier, my core aim tonight is not to assert answers to the normative and political questions that are embedded in all this. The more modest point is simply to acknowledge that the structure of the corporate form always has been, and in fact remains, replete with embedded normative and political questions. which demand careful consideration by policymakers who are too often inclined to assume that the now typical public company approach reflects some sort of cosmic truth handed down on stone tablets that inevitably works exactly the same way in all industry settings at all times. Again, in determining how to calibrate these levers, we are forced to grapple with unavoidably political questions, because the configuration that we end up favoring in any particular setting can be coherently specified only by reference to our goals. The cost-justified social and economic benefits that we hope to gain by facilitating business activity in this way. If we want to foster substantial entrepreneurial risk-taking in a particular industry context, presumably motivated by the belief that the benefits are going to exceed the costs, investment opportunities, employment opportunities, useful goods and services, and so on, then that is going to drive a particular calibration of the levers. But of course, we might reasonably decide that somewhat diminished risk-taking would be favorable in another industry context if we fear that excessive risk is apt to generate unacceptably higher costs, in which case we can adjust accordingly. Or we might decide that more substantially diminishing risk-taking would be favorable in yet another industry context, in which we adjust yet again. Now, these are just examples. Calibrations of other levers here might be undertaken, for example, if we want to foster or diminish mergers and acquisitions activity. Right? Any of a number of different goals that might be achieved through different calibrations of the levers. The central point is that this mode of depiction is better equipped both to express what's in fact happening as corporate law evolves over time, and to present the range of possibilities available to us when we're facing some problem that's arisen in the marketplace and we're trying to figure out what to do about it. Conceptualizing the modern corporation in this more dynamic way, I think, would help us ensure that we're asking the right sorts of questions and affirmatively thinking through the relevant trade-offs. And if we approach matters in this way, we might find that corporate governance offers a broader range of solutions to seemingly intractable problems than those fixed conceptions of the corporate form that are so prevalent today have led many to believe. Thank you.